This is a special report from True Crime Today and the Hidden Killers podcast.
Chad Daybell back in the Fremont County Court today. Motions filed by John Pryor, Daybell's defense attorney, and prosecutors Lindsey Blake and Rob Wood regarding a change of venue for the trial, cameras in the courtroom, and taking the death penalty off the table, amongst other issues to be discussed today. Let's go right to the courtroom to hear the audio.
We are back on the record, case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We are scheduled next to hear a motion on the state's renewed motion to reconsider change of venue. Motion filed November 15th with an objection filed November 17th. I can't recall who was arguing this, Ms. Blake?
Yes, Your Honor.
Ms. Blake, if you'd like to present argument in support of the motion, you may.
Thank you, Your Honor. And the first thing the state wanted to address was, I think, in the defense's response, there had been an indication that motions to reconsider are inappropriate or not allowed. So I just wanted to go ahead and address that first. They are allowed under State v. Montague, 114 Idaho 319. That's an Idaho Court of Appeals case from 1988. The court makes clear that it is in the discretion of the court whether or not motions or requests for reconsideration are considered. Essentially, the court pointed out that because such a request is not specifically mentioned in the rules of criminal procedure, a trial court is not without power to act upon it, but essentially it would be within the trial court's discretion. And they also looked at the federal rules of criminal procedure, which similarly do not contain any such motion, a rule regarding a motion or request for reconsideration, and specifically found the federal courts have held that a trial court is free to entertain such a motion when made. And then essentially the Idaho court joined in that finding. In addition, State v. Wolf, it's 2013 APP Lexus 86, and that's an Idaho Court of Appeals case from 2013. In that case, there was a motion to reconsider a Rule 35, and similarly, the court looked to State v. Montague for guidance and found that a motion to reconsider can be allowed, and then they went through an analysis as to whether or not it was proper with the Rule 35. Ultimately, they found that it was proper, that it could be considered by a court, a motion to reconsider a Rule 35. In that case, it came down to a timing issue. I think a couple years had actually passed on some appellate issues that court was looking at, but the actual motion to reconsider was found to be appropriate. So I do think it's clearly established in the Idaho rules that a court is allowed and can consider a motion to reconsider. The courts go on to talk about, I believe it was State v. Montague, it may have been Wolf, so I apologize, I should have had notes about that. But essentially, they talked about that there were some additional facts and considerations that were brought forward for the court to consider. I think it was in Montague, and it was regarding some evidence that was not presented at a motion to suppress by the state, but that the state had in its possession. So they had asked for a motion to reconsider and present that evidence. The appellate court found absolutely the court could consider that. They did kind of admonish and say maybe the state should have brought that the first go round, but where it was new information not previously presented to the court, they found it was absolutely appropriate for that court to reconsider. The reason I bring that up is I think we find ourselves in a similar situation. However, this information was not within the state's possession at the time the original motion for change of venue was brought forward. But we are in a new situation with the passage of time, as well as new media coverage and heightened media coverage in Ada County. So
before we go into the merits of the motion, then I'll make a comment on that, on the reconsideration, because I think there's some inconsistency in the Idaho case law, because I'm aware of other cases. I know of one in particular that, and I don't have the cite off the top of my head, but I've used it on many occasions with attorneys in criminal cases that says, unlike the civil rules and the Idaho criminal rules, there is no motion to reconsider. That being said, I do think that within the court's discretion, at times, there are certain types of motions that merit reconsideration, motions that develop additional evidence, motions in limine, et cetera. This particular motion, as it relates to a request to reconsider the change of venue, I would find appropriate. So despite potentially conflicting case law on that, I think it's procedurally proper to bring the motion. And so I'm just saying don't be concerned about a ruling based on you can't reconsider this, because I think in this case it can and should be reconsidered. So with that in mind, if you'd like to go into the merits of the argument, you can.
Thank you, Your Honor. And I appreciate that clarification from the court that there is case law disputing that. I had found the cases that specifically allowed for it. So looking at the merits of the motion itself, where the state believes that we are at is there are a couple different rules that govern requesting for change of venue. The state does not believe that we are in a position of actually requesting a change of venue. That was done by the defendant, and Idaho Code 1801 specifically says the defendant can request a change of venue if they feel that there would be bias or prejudice or an issue with holding it in the actual venue where the crime is alleged to have occurred. In this case, there's no question that Fremont County is the originating venue and the appropriate venue. The defense brought a motion back in, it was ruled on in October of 2021. It was filed before that. So it was ruled on quite some time ago. I know the state had done a motion, essentially kind of a hybrid motion to reconsider and also to consider bringing in a jury. So reconsidering some of the findings made with that order. However, now there has been a significant longer passage of time, in addition to the fact, of course, the biggest change was the defendant essentially demanded a severance, requested the severance, and was granted that severance. After that severance was granted, the co-defendant, Lori Vallow, opted to proceed with her trial in Ada County. And the reason I say opted to proceed is, as the court probably recalls, it was actually the defendant that brought the original motion to change venue and was granted the change of venue to Ada County. However, at that time, the cases were still joined for trial. And when Ms. Vallow was found competent and her case also started moving forward, the indication from her and her counsel were they were fine with the change of venue. They were in favor of it, essentially. And they never requested anything different. So we proceeded with her trial. That started the end of March of this year and proceeded into mid-May. So, and as the defense points out, some of the timing and referenced in some of these motions is off, given the hearing date versus when they were filed and when the initial drafting was started as well. But we are now less than a year from when that all occurred. During that trial, there was daily coverage. I know that's been covered in part in the motion to allow cameras back in the courtroom that was argued today by the parties. A lot of that was already referenced. There were daily reports coming out. There were interviews being conducted on the courthouse steps daily throughout the trial. Those interviews included comments on evidence that was presented, opinions on the credibility of witnesses, opinions on the culpability of the defendant and the co-defendant. I know there were some references made regarding Chad Daybell during that time as well. So with that, we just think based on the original argument made by the defendant that he thought the coverage was too pervasive here in the 7th Judicial District and specifically Fremont County, we now find ourselves in essentially that same position, but in reverse. The coverage in Ada County has been very pervasive. The state does recognize that when we look at the numbers, the coverage in the 7th Judicial District as a whole and Ada County area as a whole is very similar. Ada County numbers tend to come in a little bit higher, but we recognize the coverage is still broad in both areas. However, we would indicate that at the original change of venue, there were no specific findings made with regard to Fremont County. Fremont County was clustered into the 7th Judicial District, and in part that dealt with a witness for the defense that ultimately any testimony regarding Fremont County ended up being excluded because enough people weren't polled to make accurate or sufficient findings regarding the pervasiveness in Fremont County. Some of the other things looked to were the vigils and things that had gone on in relation to this case here in Fremont County. At the time the order had come out, it would have been approximately 14 months since the most intensive media coverage, which really circled around the finding of the children's remains. Since the finding of their remains, I believe at the time the motion was filed, it had been about 28 months. And so we have a significantly larger passage of time from when that media coverage was so intensive and from when the vigils and things were being held here in Fremont County. But we are now only about 6 months away from when that was going on in Ada County. There were crowds gathered at the Ada County courthouse steps to hear the reading of the verdict. In addition to that, In Ada County, we had approximately 1,800 jurors that were summoned in. We had approximately 700 that were subjected to voir dire, and which included some of the information regarding the underlying facts of the co-defendant's case, which are also similar to the underlying facts of the defendant's case here today. So we have a significant pool of jurors that have now been exposed to that. In addition to that, those jurors are not told not to talk about the proceedings, whereas in Fremont County, a grand jury was seated quickly and the grand jury proceedings are secret. So any jurors that sat here in Fremont County on this issue have been still ordered not to speak about that, whereas the jurors in Ada County are now free to discuss that. In addition, when we talk about individuals...
Like there's one thing I do want to bring up here that occurred in Fremont County that I think was probably the pinnacle of media exposure of the whole case. Lori Vallow sentenced here July 31st of this year in this courtroom, and I haven't looked at any objective data, but I would guess that was probably the single most covered event of either of these cases, and that occurred here in Fremont County pretty recently. So,
and I think what we had found on that is Ada County was covering that just as heavily as this area would have been. So I do recognize that occurred here in Fremont County, but it was of daily coverage.
But the event here, I guess you could say, was maybe more than that, because I know people were literally camped out here the day before. They were all around the courthouse for 24 hours before that, and the courtroom was packed to capacity. And I see that, if I'm following the logic of your argument, of being pretty problematic as it relates to potential jurors here in Fremont County.
And I can understand the court's concern with that. I guess the state's position would be, when we're looking at the media coverage and what has been broadcast, the quality and the quantity, what we found is that it was very similar in Ada County. So even though the sentencing occurred here, the media coverage was just as pervasive in Ada County regarding that event occurring here. I do recognize we had a packed courthouse. I recognize there were a few individuals that camped out on the courthouse lawn. I would also indicate during the trial in Ada County, the courtroom most days was packed to capacity. There were some days that it wasn't, but we had an overflow room to allow for individuals to watch the trial. And I do think that that was attended at times. Through certain portions of the trial, I think that was pretty packed as well. I didn't go down to look, but I know the courtroom was at capacity for some of the events with that trial, including, I think at a minimum, the closing statements and also the verdict being read there in Ada County. But I do recognize the court's concern with that. I guess the state's position would be that the coverage did not continue, even if it was pervasive, even if that was a highly covered event, it did not continue for months after that. Ada County's interest seems to have been piqued even more so by the trial being held there. We had individuals in public roles in Ada County that gave interviews. The only reason I bring that up is I think oftentimes if it's someone you know, someone that may be a public figure in the area you're from, you may be more likely to hone in on that. Those interviews were conducted there at the courthouse in Ada County. So displaying the courthouse, I think there was note of some vigils being held here at the Fremont County Courthouse years ago. And so again, just looking at that raised some additional concerns and some additional facts that the state thought should be considered at this point in time. And I think, again, just really focusing on the defendant's initial arguments in his motion to change venue. Essentially, it was a motion to change it out of the 7th Judicial District because there was really nothing presented specific to Fremont County. So the state's position is Fremont County does have a smaller population than Ada County, and we absolutely recognize that. But we do believe, given that we were able to seat a grand jury, given the passage of time from some of the main events occurring here, and I will give the court, with the exception of the sentencing, the other main events that have occurred here, there's been a longer passage of time from when we had this massive trial. The court had also focused on the media coverage regarding the co-defendant in the initial order granting the change of venue. That coverage only intensified during the trial there in Ada County. Again, the state does recognize that coverage was here in the 7th Judicial District as well. But again, nothing specific with Fremont County has been presented or located regarding that. We do believe that a fair and impartial jury could be chosen here in Fremont County. I know this matter has been brought up in a motion to reconsider, but of course also factoring in the cost to the county
Judge, I'm going to object at this point. They didn't bring up the cost specifically in their motion, and quite frankly, I've been quite patient. The fact of the matter is their argument was based literally to the media coverage, and if they're going to be allowed to expand on this, then I want a continuance, and I'm going to go back to every little item, and we'll have to go through this again. So at this point, I'm objecting to this financial argument because they did not make any mention of that.
I thought there was a mention.
There was a brief mention, but I'll just keep it brief. That is all I was going to say really regarding that. Is what was contained in the motion is obviously some of the factors the court can factor in and consider when determining whether or not a change of venue is appropriate are the costs and things. I think the court addressed that in the prior motion. The state, Fremont and Madison County are cognizant of that issue as well. And so we just bring that to the court's attention also. As an alternative in our motion, we had indicated, again, looking at the population of Fremont County and considering that may be a concern for the court and a factor because of the pervasive coverage in Ada County, because the defendant opted to request a severance and the co-defendant opted to proceed in Ada County. I think we are now in a different situation. So we would ask the court to reconsider whether or not Ada County is the appropriate change, the appropriate venue, if the change of venue is still determined to be appropriate. Given that.
Ms. Blake, do you have I don't know for sure the number. Do you know currently what is the population of Fremont County? I mean,
I should know.
I think it's around 14,000 people.
That sounds about accurate. I don't know when the last census was done. I should have that information, but that sounds accurate, which I do think is a large enough number to pull in 1,800 potential jurors if we were to follow what we did in Ada County.
All right, and I would need to confirm. I had heard at one point from a jury commissioner here that I thought there were around 2,000 qualified jurors total out of Fremont County. And at our last trial, we pulled 1,800 for starters, and that was not a capital case. And we may have to look at additional issues that come up with juror disqualifications with a capital case. Just looking at the numbers there, though, but if we're looking at around that 2,000 qualified jurors, and I just note that something I did look into and have to consider, despite the media coverage in Ada County, I mean, it's a whole nother world in terms of population there. They have approximately between 275 and 300,000 qualified jurors out of Ada County. So it's, 100 times, I guess, the amount of potential jury pool there. And I'm just making some commentary here, and I'm not deciding the motion at this point, just making some commentary, but I am fully cognizant of the burden and cost and expense and concerned about that as well. So I do appreciate you raising that. The court has to take those issues seriously when determining the appropriate venue for the trial in this case. So apologies for my interruptions, but if you have any further argument, you can present that.
That's no apologies necessary. I would just indicate while 1,800 jurors were polled in Ada County, because I know there's a concern we may need to poll more, but only about 700 of those actually were subjected to the voir dire. So I think when we look at numbers, we may not need to go over a mark that Fremont County can easily meet. It's my understanding Fremont County does have a high percentage of juror turnout as well when they are summoned in, higher than some of the surrounding counties. But again, then that's why we bring up the alternative of possibly considering another venue such as Twin Falls, Bonneville County, Bannock County, jurisdictions that have a higher population that would be able to it would be easier for them to meet the juror numbers than Fremont County, but would not have been subjected to such pervasive media coverage as Ada County.
All right. Well, I appreciate the argument and comments, Ms. Blake.
Thank you.
Let me hear a response now on the state's motion to reconsider the change of venue issue. Mr. Pryor.
Judge, I agree with the court's assessment. My review of the case law was that, at least limited review of the case law in this regard, was that the court, there's no rule or law statute that allows for a motion to reconsider. The court can obviously do that. And in the present day case, the court sua sponte decided to revisit the camera issue. And I appreciate the court's ruling on that issue. And just as a clarification, it was Mr. Daybell's family in Utah and outside of Fremont County that was unable to participate. And given the case was ruling, they'll be able to at least watch, and we're thankful for that. This is my concern, Judge, about what they're trying to do here. They're trying to revisit a situation that took a significant amount of time to put together a presentation talking about all of the concerns about having a case in Fremont County. And if the court took the time to revisit its order, there were a number of factors that the court took into consideration. And the court took the time and a length of time to analyze and evaluate what would be the best situation. And one of the concerns, Judge, was the inflammatory nature of what was transpiring in Fremont County at the time. And you talked about it in your order that there was a lot of inflammatory information that was being disseminated out there, and this was of a concern. I had an opportunity to go home and visit my family over the holidays. And I went by a site that 40 years earlier, as a young man in high school, was the scene of a horrific situation regarding one of my very close classmates, the death of that classmate. And that in no way diminishes or minimizes what happened in this case, and that's not the intent here. But Judge, the emotions of seeing that 40 years later brought back the same very harsh feelings, the very same strong feelings, the anger and the resentment, and that event took place 44 years ago, and all it took was me driving by that site, and it brought it all back. And it was a horrific situation. We're talking 14 months. We have a situation where the prosecuting attorney's office at the courthouse in Madison County and Fremont County had all sorts of signs on the courthouse grounds. We had all sorts of publications. The prosecutor can't convince me that the feelings and the anger and the emotion has diminished. And in fact, in many ways, it's getting stirred up again. How's it getting stirred up? The court took some of my information I was going to present, and that Lori Vallow was sentenced. Judge, I heard they were camping outside. They were staying overnight to watch that. My understanding is, and I didn't show up because I wasn't going to be part of the same media circus that she was talking about. But the courthouse was full. And where in this courthouse are they going to cover the overflow crowd that they had during the Lori Vallow trial? Where is that going to take place here? And I think it's highly inappropriate for them to forum shop and say, well, we're not going to have it in Fremont County, but let's pick some of the other counties like Bannock, or let's pick one of the other counties in Idaho Falls, or let's even do Madison County. And unfortunately, the court in its order talked about the religious underpinnings that are part of this case. If we're really going to effectively consider moving this case, and that's really even something that's feasible, less than 120 days before this trial is supposed to start, 120 days. Now, Judge, I've done preparation and I've made plans. And if I'm going to have to change those plans, if we're going to do this, Judge, let's move it. If they're so concerned about pervasive media coverage, let's all go up to Coeur d'Alene. Let's all go up to Grangeville, and let's do that because there's just as much population. In fact, other than Boise, the population up in the Coeur d'Alene, Post Falls area, that's a large population. And we don't know what's going on up there. We could move it up there. And let's all of us travel up there for the next 10 weeks and do that. And let's see how that works out. The reality is that the trial of Lori Vallow worked. There was room. They handled all of the situation properly. There were the facilities to handle this. And Judge, for the last at least 2 or 3 months, the construction that's going on in this courthouse, and I just heard it again 3 or 4 times, when is that going to end? When are they going to be done with the construction out here? Are we going to be listening to that during the trial? Because they can tell me and answer that and say, oh yeah, Judge, we've been told that it's going to be done in the next 2 months. But nobody can promise when we're going to stop hearing the drills and the falling and everything else that's been going on during this hearing. But back to the substantial argument, Judge, if you look at the numbers, the court pointed out, and I checked on this, there's a little over 300,000 qualified jurors in Ada County. with a population of in all of Ada County, 750,000 people. So 300,000 qualified jurors. We need less than 1% of the jurors from Ada County to bring in a jury. And if we even took 1%, that would be 3,000 jurors. We have to go back to what the reason for change of venue is. It's to try to find jurors that either haven't heard about this case or haven't formed an opinion, that haven't made a decision regarding this case. And to some extent, you were effective in doing that during the Lori Vallow trial, to some extent. But we only take 1% of the jury pool from Ada County. On the other hand, we're going to take over 10% of the jury pool from Fremont County. I think it's highly inappropriate for the court to even consider anything other than Ada and Fremont County. Quite frankly, I think it's inappropriate even for the court to consider this. I object to this motion, and I object to the fact that a defense attorney is the one, and the defense is the one who's supposed to file a change of venue. And in essence, what this prosecutor is trying to do is rechange the venue, and they're doing a change of venue that's not even permissible under the rules. They can do a motion to reconsider. What they can't do is do their own change of venue, which is in essence what they're trying to do here. But back to Fremont County. We have all the inflammatory stuff that the court talked about in its order. The pervasive amount of information that was being disseminated. And today, what we have is we have Mr. Eaton here today. And Mr. Eaton was here today, and he hired legal counsel and said, hey, I run East Idaho News, not Idaho News, not Western Idaho News, not Northern Idaho News. I run Eastern Idaho News. And his readership and his group of folks that he represents in East Idaho News, that he disseminates all this information on the eastern part of this state, are highly interested in hearing this case. They are so interested in hearing this case that he hired an attorney, a very well-known attorney, to come up and say, we want to broadcast this so that all of my folks who partake in reading and viewing the stuff that I disseminate out there in East Idaho can have a chance to do that. Because we don't have the facilities here to accommodate all the people in East Idaho in this courtroom to watch the trial. So we need to have cameras. And that wasn't from me, that was from their lawyer. 14,000 folks in Fremont County, 2,000 voters that are capable of being voters. If we need more than 2,000, Judge, we have to pull them all in. We have to, in essence, pull every single juror that's capable of being able to participate in a trial over here. Now, the prosecutor brought up the grand jury, and I'm not going to violate the court's order in regards to discussing the situation regarding the grand jury. But there were issues that I addressed in my previous motions regarding the grand jury, and Judge, I'm not going to get into specifics, but the court knows what I'm talking about, and the counsel knows what I'm talking about in the ability to obtain a grand jury and pick a grand jury. I want to point out further that this is that almost every law enforcement officer in this case, with the exception of the FBI and Bode Laboratory, all of the officers who are investigating it, who are at any part of this, Fremont and Madison County, all of those witnesses, the vast majority of my witnesses. Now, I don't know how many witnesses the state's going to have. At this point, I don't want to be held to a number. Judge, there's a significant number of witnesses. And the vast majority of those witnesses are all from Fremont and Madison County. A large number of those folks that we're going to be calling. And those large number of witnesses that we're going to be calling have family, have friends, live in the community, and this is going to create a nightmare. We are not going to be able to obtain people who don't know witnesses in this case. We are going to be cutting out vast numbers of witnesses, and just from a number standpoint, this is going to be a huge problem. I'd ask the court to revisit its order again regarding the inflammatory nature. I understand, and the court noted that in its order, you said that you can get a fair trial in Fremont County. And I truly believe that. I truly believe that in any standard case, the average criminal case, the folks in this community would provide a fair and just verdict in any other case. But as the court pointed out in its order, this is not an ordinary case. This is a high-profile case, and it doesn't matter that the media attention occurred in Ada County. The media attention has saturated the entire state, the entire country, and my sister, who is going to hate me for mentioning this, who lives in Europe, knows all about this as well. It's going to be very difficult to find jurors that aren't related to people in Fremont County. We're going to have a very difficult finding people who have not been exposed to this, of those 2,000. And it's going to be far easier if we have to pick from a pool of 300,000 as opposed to 2,000. And Judge, for all of those reasons, I'd ask the court for you to deny their motion to reconsider.
All right, thank you, Mr. Pryor. Ms. Blake, any rebuttal argument?
Just briefly, Your Honor. I think there was a lot of talk about the amenities and the different things with the courtroom facilities. The state's position is that is not appropriate to consider as a reason to change venue. I don't think that's ever contemplated in case law or in the rules regarding change of venue. Additionally, it was mentioned that the state cannot bring a change of venue. Idaho Criminal Rule 21A clearly indicates either party can. However, the Idaho Code references specifically the defendant. However, the state does not see this as bringing a new motion for a change of venue because Fremont County was the appropriate venue, and the state's position is it remains the appropriate venue. We hold all the other hearings here, just simply trial was moved to Ada County, and we have just asked the court to reconsider the granting of that given the new information. They specifically mention East Idaho News, that they are here. What the state has found is East Idaho News actually has an international following. People from around the world, as well as the nation, including the whole state of Idaho, follow East Idaho News. It is not a news outlet that is specific to East Idaho. In fact, there's nothing to show that there are more followers here in Eastern Idaho with that coverage. In addition, East Idaho News was over in Ada County, was conducting interviews over there. So I don't think in any way, if anything, in the state's opinion, that kind of becomes a wash given that information. And I think, so as the state's indicated, looking at the prior concerns raised by the defense, we think those prior concerns now exist just in relation to Ada County. It sounds like the defense is of the position that it should remain in Ada County, even though those concerns exist, and there has been that pervasive media coverage. But based on that new information, we felt it appropriate to ask the court to reconsider and to present this information to the court for the court's review. So we would ask the court to factor all the new information in determining whether or not moving the venue back to Fremont County, or essentially reconsidering and changing the court's position on the change of venue, or whether or not a change of venue to another county should be considered if the court determines that a change of venue is still appropriate given all the new information. Thank you.
All right, thank you, Ms. Blake. Counsel, the court is going to take this issue under advisement and issue a written ruling on the motion. I know the timeliness is of the essence here with the trial coming right up, and the parties need to know for planning purposes, so we shouldn't have too long of a delay in getting an opinion out that will address the state's motion. We've got 3 additional motions. Counsel, I guess I would like to inquire at this point if you want to forge ahead or if you want to take a lunch break. I don't want anybody to feel rushed because we're not breaking for lunch, and we certainly can do that. And if you think it's going to be another hour or so of argument, I would suggest we probably do lunch. But Mr. Pryor, your motions, what are your thoughts here?
Judge, there'll be a relatively brief argument on the first one. On the last 2 motions, Judge, those are procedural and for purpose of appealing potential appealable issues. So there'll be almost no argument on, or little to no argument on the last 2. So I anticipate 5 to 10 minutes on the first one. I don't know how long Ms. Blake's going to talk. I'm not going to hold her to anything, but It's going to be relatively brief.
Okay, so you'd prefer to just keep going?
Yes, Your Honor.
Want to keep going?
We're fine with continuing, Your Honor.
Okay. We'll next take up then a motion in limine that was filed by the defense. It's a motion in limine to state. Just give me a motion to look. Motion's filed November 9th by Mr. Pryor on behalf of the defendant, entitled Motion in Limine to Limit State to Consistent Arguments on Defendant's Relative Culpability. And that was filed, as I mentioned, on that date. There's been a response filed and an objection by the state filed November 22nd. So, Mr. Pryor, I've reviewed the motion and the state's objection. If you'd like to present oral argument, you may.
And Judge, I'm going to be very brief. I'm going to go back just a little bit of the history. Part of the history, Judge, is at one point during the proceedings, I believe it was the pretrial, the court had discussed what the issues regarding discovery. It was found that there was still some outstanding discovery that had not been provided by the state to the defense. And I'm talking in regards to Lori Vallow and Chad Daybell. At that time, Mr. Daybell had waived his right to a speedy trial. Ms. Vallow had not. As part of a sanction, the court sanctioned the prosecuting attorney for not turning over the discovery and withdrew the death penalty as a result of that case. In this particular case, because Mr. Daybell had waived his right to a speedy trial, we could proceed, and the case is now granted. It was my request to sever, and that was my request to do that. But at this point, Mr. Daybell needed additional time, and we proceeded with a separate trial. That sort of ties in actually with the venue as well, but at this point, that's been settled. But in regards to this case, during the trial of this case, the closing arguments were made. And Judge, I submitted the case law that applies, and I appreciate the state pointing out State versus Pierce, which they did in their response. And it basically confirms what I'm saying, Judge. These folks are co-defendants. That's what's very important. They are co-defendants in a case. They are called co-conspirators, and up until the state did not turn over the discovery, and basically the cases were separated, and that was really the main reason why they were separated. They were going to have a trial at the same time. Now, it would have been impractical for the state to argue in front of the jury if both of the cases were together and say the things that Mr. Wood said. Chad is not going to act without Lori saying so. Chad seeks confirmation from Lori. Chad is not going to do anything without Lori. It's all Chad. It's all Lori, 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 Lori. Now, the state provided some factual issues as it relates, and this is all referenced, Judge, in the transcript of the trial. It is all noted in my response in terms of the trial transcript as to where it was noted and what Mr. Wood said. This is the concern, Judge. If these trials had been together, Mr. Wood would not have been able to say, Chad is not going to do anything without Lori if the trials were combined. Mr. Wood would not have been able to say, this was all on Lori, and she was the one driving the ship. She was the one directing this so-called conspiracy. She was the one in charge. And then turn around when it was time to talk about Chad and say the same thing. That would have been terribly inconsistent, and the jury would have said, which one is the truth? Which is the truth? Which is the truth, Mr. Wood? Was it Lori driving the force of the ship? Or was it Mr. Daybell driving the force of the ship? Which one of these was the one running the show here? And what he said in front of, and it was very clear, there's no confusion here. Mr. Wood specifically said this was Lori, and she was the one in charge of the conspiracy. There's no ifs, ands, or buts about that. He was very clear. Now, the case law, particularly the federal case law, and Pierce, alludes to the fact that a prosecutor cannot, in one instance, sit there and tell one set of jurors a year ago, or whatever, 8 months ago, say one thing to one set of jurors and stand up in front of them and say, Lori Vallow was the one running the whole show. Tell that set of jurors that, and then turn around in Chad Daybell's trial that's going to occur starting hopefully in Ada County in 4 months, and tell them, oh, well, I know I told the jurors in Lori Vallow's trial that Lori was in charge and she was the one driving force behind everything, and she was in charge. But you folks here at this new jury in Ada County in April and May, I'm going to tell you something different. I'm going to tell you now I've decided that now Chad is the one who was doing all of this. And it was all Chad leading the conspiracy. It was all Chad who was the leading force, and he was dictating everything. They're not allowed to do that, and the federal case law supports that. So the prosecutor responded in terms of culpability, but quite frankly, Judge, it's making the legal argument. You can't make one legal argument in terms of who is the culpable person leading the conspiracy, in charge of the conspiracy, and make representations in a court of law to one juror pool and a jurors in a trial, and then turn around in a brand new trial of a co-defendant and make different representations. So what my motion in limine is saying is that Mr. Wood can allege any of the facts he wants against Chad Daybell. What Mr. Wood cannot do under the case law, at least the federal case law and under Pierce, is Mr. Wood cannot make the representation that Chad Daybell was the one behind and leading the conspiracy, was in charge of everything. He is not allowed in closing argument or otherwise to say, hey, you know what? I told the jury in Ada County one thing. I'm not allowed, I'm going to tell you that, well, I know I told the jury in Ada County that, but I'm going to tell the jury in Ada County in Chad's case that, well, actually it's Chad who was in charge. You're not allowed to make that inconsistent representation. They can make any factual representation they want, and I'm not going to stop them from presenting any facts that they want to present as long as they're relevant. But what they can't do is make inconsistent or contradicting arguments to a jury saying one person was the leader of the conspiracy in one co-defendant's trial and make a different representation in Ada County. And what this motion is saying is we cannot allow Ms. Blake or Mr. Wood to tell the jury in Chad's case that Chad was in charge of the whole thing and that he was running the show. Now, in addition, Judge, and I'll cover the other ones now, the culpability argument is this, and it's just a fundamental fairness and due process argument, and it applies in this one as well. If you're going to say to a jury in Ada County that Lori Vallow was the one in charge and he made those representations, it's completely, he can't change that. It's a public record. He said to that jury that Lori Vallow was the one in charge of this conspiracy. And it's a culpability argument. And the fact is that Lori Vallow, who had her death penalty pulled as a result of the prosecutor not providing discovery and was sanctioned, now what they're doing is they're seeking the death penalty against Chad Daybell because he waived his right to a speedy trial, and he was not the leader of this. According to Mr. Wood's own words,
Mr. Pryor, the death penalty was on the table way long before the cases were severed, so they're not seeking it against him because he waived speedy trial.
and that's not what the point, Judge. The point is that if we're really going to take Mr. Wood for his words, and we're going to accept that I would assume Mr. Wood was telling the truth to a jury, because if he isn't, he's got some other problems. And if he makes inconsistent arguments to a jury in Canyon or in Ada County, in Mr. Daybell's case, he's got other problems. But that's not the point. The point is simply this, is that when you're talking and making a representation to a jury in Ada County in Lori Vallow's case, and you say to those jurors that Lori Vallow was the one who was in charge of the whole conspiracy, and that Chad would do nothing unless Lori told him to do it. And Lori and Alex were following, or Chad and Alex were following Lori's lead. He doesn't get to say the same thing in the other trial. And on top of that, we're seeking the death penalty against someone who is allegedly is a lesser co-conspirator and wasn't even the leader of the conspiracy. So that's where the death penalty arguments, Judge, and I will leave it at that.
All right. And to be clear then, Mr. Pryor, did you incorporate your other two motions within that argument as well, or did you want to?
I did, Judge.
Okay.
I did, Judge, and for the moment, for the interest of saving some time, that's where the arbitrary and capricious and the other arguments come in, is that if you're seeking the death penalty against someone who is, at least according to Mr. Wood's words, were not the leader of a conspiracy, my argument is simply this, is that you're seeking to put someone to death when in fact Lori Vallow, according to their theory of the case, was the leader of this entire scheme.
All right, thank you, Mr. Pryor. So the court's now heard the argument as it relates also to the motion to strike the death penalty as arbitrary and capricious, and also the November 9th motion to strike the death penalty on relative culpability. Those were incorporated into that argument. So, Mr. Wood, are you going to be presenting argument as it relates to each of those three motions?
Your Honor, I was planning on arguing the motion in limine, and Ms. Blake was planning on arguing the others.
Okay, and that's fine. You can divide those up. I'm fine with that.
Lori Vallow was the one running the whole show. Never said that. She was the one in charge of the whole conspiracy. Never said that. Chad would do nothing without Lori telling him to. Never said that. Not the leader of a conspiracy. Never said that. So the defendant's contention is that the state argued at Lori's trial that Lori was more guilty or in charge, and therefore the state cannot argue that Chad is equally guilty at his trial. And that by claiming Chad is equally guilty, we would be changing the core theory of our case. This is the state's contention. We are not changing the core theory of our case. The state's core theory will be the exact same core theory as argued at Lori's trial, that Chad and Lori Daybell, along with Alex Cox, by acting together, by way of conspiracy, planned, aided, and abetted together, and encouraged and caused the deaths of Tylee Ryan, J.J. Vallow, and Tammy Daybell. Those same individuals conspired to fraudulently steal Social Security funds, and that Chad Daybell committed insurance fraud when he claimed the life insurance benefits for his murdered wife. It's the same theory. So I'm going to divide this up. The defendant's motion is not based in law. It's not based in fact either, but it's not based in law. I'll talk about the law first. The defendant's argument ignores the basic law of conspiracy. Conspiracy requires an agreement and one overt act by one of the parties to the agreement. Once that is established, all conspirators are equally guilty. There's no relative guilt in a conspiracy. Guilt stems from the agreement that a crime should occur. This whole who's in charge, who's the leader, that has nothing to do with the guilt. The defendant has failed to argue how he should be free from the law of conspiracy. He's ignored that basic premise of that law and instead is attempting to convince the court to adopt a legal framework that simply doesn't exist. The state's position that this court is actually precluded from granting this motion by a decision it made at Lori Daybell's trial. Her trial, after the state arrested, the defendant in that case filed a motion, a Rule 29 motion for acquittal. And this defendant's whole argument is based on Lori's case. So we're going to go back to that. They filed a motion to acquit, and this court found that the state had presented sufficient evidence that Chad Daybell had committed overt acts to allow a jury to decide. Now, Chad wasn't on trial, and I want to be clear, this court wasn't saying Chad did those things. It wasn't saying the jury should find that Chad did those things. But it did say, this court did find, there was sufficient evidence of his overt acts to go in front of the jury. And in a conspiracy, one overt act by one conspirator does get held against the other. That's the law. And the court found multiple occasions. Looking at that, the same transcript, the same day of the closing argument, page 3796. Text messages dealing with light and dark ratings. Those were between Chad and Lori. Text messages entered into evidence between the defendant and Chad Daybell, meaning between Lori and Chad Daybell, about Tamara Daybell being dark. And Chad Daybell said, I feel she will be gone soon. About an application to increase life insurance to the maximum amount allowed. Cell phone data and messages admitted. sufficient evidence to send to the jury, overt acts dealing with the conspiracy. And so it would be a polar opposite ruling and entirely inconsistent for the court to now say, yeah, you presented sufficient evidence to go to a jury before, but now you don't get to make the same arguments. Further in the law, the defendant's argument ignores Idaho Code 1940-30, which states that the distinction between an accessory before the fact and a principal and between principals in the first and second degree in cases of felony is abrogated. All persons concerned.
Sorry, Mr. Wood, what's the citation on that?
1914-30.
Thank you.
All persons concerned in the commission of a felony, whether they directly commit the act constituting the offense, or aid and abet in its commission, though not present, shall hereafter be prosecuted, tried, and punished as principals. And it goes on a little more. So in Idaho law, there's no distinction when you're dealing with co-conspirators or aiders and abettors between the trigger puller and the aider and abettor or the co-conspirator. They're all equally guilty. At Lori's trial, the state presented ample evidence of Chad Daybell's involvement in Tylee, JJ, and Tammy's murders. What was some of that evidence? Now, I know that the defendant's just talking about closing argument, but he's opened this door to talk about the trial. It all comes in. So what was some of the evidence? Text messages clearly talking about the impending deaths of the victims. Text messages and other evidence of an affair that provided a motive for the murders. Evidence regarding financial gain that was another motive. Where did we find Tylee and JJ's remains? In Chad Daybell's backyard. And who told us where to find them? The evidence was that Chad Daybell told law enforcement where to find them in his infamous text to Tammy about killing a raccoon and burning limbs. That's not saying Lori's in charge. The defendant's argument about the state's closing argument is factually invalid. The transcript of the state's closing argument, the initial closing argument, is 42 pages. The rebuttal is 10, so 52 total pages approximately. And the defendant ignored and or omitted 99% of what was actually said. They picked out a few phrases, none of which are the full statement or sentence. None of which are the full statement or sentence. And there's one in particular that I think really showcases this and highlights the lack of validity to this argument. In the defendant's brief, he speaks about a quote about Lori being the conduit of information to Alex. And when you actually look at the citation that's given there, he literally omits the first part of that sentence, not just a whole statement, the sentence that talks about the relationship between Chad, Lori, and Alex. So never mind that we're talking about Chad. We're just going to take this little snippet and try to twist it into something that it doesn't say. And so what else did he leave out? They ignored the state's language, any of the state's language that placed blame on Chad Daybell. They left out the many times that the state referred to Chad and Lori as they in regards to planning, in regards to the conspiracy. They left out the state said that Chad and Lori are driving this together. This is all in my brief. They left out when the state references Chad's text to Lori about JJ, Tammy, and Tylee dying. They left out when the state referenced Chad and Lori Daybell's plan and their future together. They left out the phrase referencing Chad, Lori, and Alex, which was used at least twice, acting together. They caused the death. We said that in regards to Tammy. We said that in regards to Tylee in the closing argument. Acting together, they caused the death. We didn't say Lori was in charge and made Alex and Chad do this. Now, to be clear, we did talk about Lori manipulating Chad. We talked about Chad manipulating Lori. That doesn't make one of them more guilty or less guilty. They left out the evidence presented by the state of Mr. Daybell's so-called patriarchal blessing to Alex Cox, which was strong evidence of religious manipulation of Alex on this defendant's behalf. They left out the evidence presented at trial that Alex believed Chad said everything Chad said, and he'd do whatever Chad told him to do. In their brief, they make a common thread argument that at one point when we refer to Lori as the common thread. Being a common thread doesn't make you more guilty or less guilty. In fact, the fact that this individual, that this defendant married within weeks after his wife's death is what the evidence showed. The evidence showed had an affair with. The fact that she's a common thread is highly inculpatory for this defendant. It doesn't make him less guilty. The argument of seeking confirmation is evidence of an agreement, it's evidence of a conspiracy, and it's evidence of encouraging the murders of Tylee, JJ, and Tammy.
This has been a special report from True Crime Today and the Hidden Killers podcast.